Oh, and Mr. Chair, if you would, at the beginning of the meeting, if we could do just a basic little introductions,
Okay.
since that we have a new member on it, we can get it on the recording.
All right. Well, we'll call the I'm sorry.
I was about to do that.
Nicole?
Mr. Hellman,
Present.
Ms. Dixon, Howard,
Present.
Ms. Trinkler,
Here.
Mr. Harb is absent, Ms. Hoover.
Present.
Sir, we have quorum.
Wonderful. Would you read the notice of meeting, please?
Okay. Notice of the May 11th, 2016 meeting of the Collection Service Board was posted to the Collection Service Board website on May 5th, 2016.
Okay. And has everyone had an opportunity to review the agenda? Are there any questions or additions to the agenda?
No.
Motion to approve those?
So moved.
Second.
And seconded, all in favor?
Aye.
Election of officers. It's been a long time since we've had an election of officers. I've been the chairman for years, and have to step aside to let somebody else take the helm, and you get twice as much money as the rest of us do, so.
I'm tickled to death to nominate you to stay right where you are.
Exactly.
Oh, I knew I should.
So I would like to make that nomination. Bart Howard be chairman.
Are there any other nominations?
I'll
Motion
second
by
it.
acclamation. Motion, it's been seconded that I remain chairman. All in favor, say aye.
Aye.
Okay, thank you very much. And we elect a
Vice chair.
Vice chairman?
Yes.
Nominate Elizabeth Trinkler for that spot.
I'll second that nomination. All in favor, say aye.
Aye.
All right,
Thank you.
here we are. We're a good team, aren't we? The minutes of the last meeting, has everyone reviewed those from the, I think Cody sent those out to us. Are there any questions, changes, or additions to those minutes? If not, I will accept a motion to approve those.
So moved.
Second.
Moved and seconded, all in favor, say aye.
Aye.
Aye. Director's report. Cole?
Are fast, my goodness.
Oh, aren't we?
I'm just scratching to keep up on that, on the minutes. Give me just a second. All right. If you turn to page 17 on your iPads, I'm gonna just give you a little crash course. If you touch anywhere on the agenda, it'll take you to that where place in the iPad.
Okay.
And then if you see at the bottom, that's the TOC button, will take you back to the front page. Director's report, it'll take you to the director's report. In theory, yes. All right, right at the top is the 5-year budget report for the Collection Service Board showing total expenditures, net revenue, and the adjusted as a reserve balance. And then just below that is the year-to-date information, including our budget plan of $203,000, the total expenditures as of March 31st, 2016, which is $87,017.81, and the total revenue generated by the program thus far has already met our budget plan expectations, and that is $204,460.92. These figures do not include the cost backs and investigation costs that will be applied at the end of the fiscal year, included estimations for what those will be and as of now. And currently, the estimated cost backs will be $45,000 for administrative services and $752 for investigative costs. There are no legislative updates to report this month. There are two new applications on your iPads to review, the initial application and the renewal application. They're similar but not quite the same. And then we have one application that an applicant has asked the board to review, which is application for renewal 1703, which recently expired, for the law offices of Ed Overcash LLC. He requested that the board use his income tax return in lieu of financial statements required. We repeatedly requested the financial statements, but Mr. Overcash wanted to present this one for consideration to the board. I've attached what he sent us and the exchange. So I will let you review that and make your recommendations for both the applications and for the Overcash's renewal.
Okay, let's back up just a moment and introduce and welcome our newest board member. Nicole, will you make the introductions, please?
Yes, our newest board member is Miss Angela Hoover. She is an attorney. And beyond that, this is my first day meeting her also, so I'm going to let her introduce herself a little bit.
Okay. Well, my name is Angela Hoover. I'm an attorney in Franklin. I'm a partner in my family law business of Ainley Hoover and Hoover. My father and I practice together in Franklin, and my mother and my stepfather practice in our other office in Paris, Tennessee. And we have just a general practice. We do a little of everything except bankruptcy. So
You do collection work?
very little, only if it's a current or existing client in some other area and they need help with something, or they call and say,
Yeah.
I've got somebody calling me. That's it.
Do you do consumer work with that have collection problems, or?
Not usually.
Okay. Welcome.
Thank you.
I'm glad to have you.
Appreciate it.
This will be a lot of fun.
Glad to be here.
Sorry, we got out of order.
That's okay. That's okay. You are the chair, and I
Don't
serve
do
at your
this.
pleasure.
We're talking about Mr. Overcash.
Yes, his information is immediately subsequent to the director's report on page 18. It shows his financial statement, which is actually his tax return, and then his application then follows that. I just put the tax return first because that's sort of the issue with the application. I asked him if he was operating as an attorney collecting debt, but that doesn't seem to be the situation, because I did send him the exemptions to the law, and he said that didn't apply.
Makes me wonder why he wants to do that, but neither here nor there. The rest of the board, are there any exemptions in our statute that allow us, or Nicole, is there any exemptions in our statute that allow us to accept a tax return in lieu of a balance sheet signed by a CPA or an accountant?
So, the part that it is relevant, let me get to that, is
Simple enough for a CPA to prepare a compilation report. It's not a big matter.
622112, it says expiration and renewal of licenses, and it indicates all the things that are required. And it says applications for renewal of a collection service license shall be submitted to the board prior to the expiration and shall be accompanied by a fee set by the board, evidence of renewal of the bond or certificate of deposit under the terms required by this chapter, a current balance sheet prepared by a licensed public accountant or a certified public accountant, and proof of all taxes, proof that all taxes that are applicable to the collection service license that are due and payable have been paid. So those are the basic requirements of renewals.
I don't think that the board has the authority to allow him to use his tax return in lieu of a financial statement prepared by an accountant.
I agree, and, I was thinking, well, if it's just him and he's got maybe
I know.
employees, so this is not just a little
Right.
shop, so that makes it even stranger to me that with that size operation, that there wouldn't be a,
On page 30 in his email, he's saying it could cost him $500 to $600 to get this work done by a CPA. I mean, I don't have a lot of sympathy. He's got revenue over $1 million, revenue, not income, but revenue over $1 million he can afford. I mean, but
10 people, I think he could,
yeah.
Spring
On the
it.
other hand, we don't have the right to
yeah.
override what's.
I'd entertain a motion to deny Mr. Overcash's request to use his tax return in lieu of a financial statement.
I'll second Elizabeth's motion.
I'll make that motion, yeah.
All in favor say aye.
Aye.
Where are we now, Nicole? Legislative update?
I did the legislative update. If you could just look over those applications and see if they are satisfactory to the board and follow up with a vote so I can post them to the website.
We probably need to talk quickly about the legislative proposals for 2017. And actually, under just legislative updates quickly, the Right to Earn a Living Act passed. And essentially what that's going to do is each licensing agency by the end of this year is going to have to submit a copy of all of our existing regulations pertaining to the licensing authority. And we're basically going to have to go through and make sure all of our rules are beneficial to the public. And so that's going to be a yearly thing that's going to have to be done by legal, just to make sure that we don't have anything out there that the governor doesn't see fit to help the public welfare. In addition to that, they've asked us to come to each board and discuss the 2017 legislature and see if you have any proposals that you would like to submit for new statutes in the collection service area. They ask us to tell you, give it a thought for a minute and remember that they should reflect one of the governor's priorities, which are education, jobs, and efficient and effective government. And in addition to that, when we're thinking of these legislative proposals, could we do this via rule and not put it out there for the legislative to have to look at? It's competitive between all the boards, so basically it would go into our admin proposal. So if you guys can think of anything that you would like to see changed or done in the statutes, this would be the time to talk about it so we can get that submitted on your behalf.
Thank you, Sarah. I agree with the governor, make it easy for commerce. Also agree that it's important that this board and these staff protect the consumer. So that's kind of a juggling act that we have and the governor has and the legislature has. I'll think about proposals. I don't have anything off the top of my head that
I can't either.
Yep. I mean, if you happen to think of anything, we could discuss it at the July meeting if we need to. We've been given an end of May deadline that is flexible, so we can tell them that we've talked to you today and that you didn't have anything today, but you might have something in July if that happens.
Well, are we back on applications now? Is there other applications?
Just the proposed applications, the initial and the renewal.
Oh,
Give 'em last
the
month.
new application.
I made the revisions that were requested last time, and essentially I'm showing them to you this time to ensure that I have made the changes you requested and that these would meet the board's requirements for initial application and renewal.
And that's kind of like what I put in front of you with Colorado and Illinois. I know you'd had some questions about what other states were asking for on their applications. Most of these states that ask for ownership percentages and that stuff, they had it in their statute that that was required. So I just wanted you to see that. And additionally, I did talk to Mark Green. I know you'd asked Keeling to talk to him about rulemaking. And he did say that it would be okay for you all to make a rule in reference to the change in ownership. So if you wanted to actually make a rule where you defined what a change in ownership was, then we could say, you know, a change in ownership is 50% or 10%. That way we wouldn't have to have a new application every time a little change happened. I know that that's come up since your last meeting a couple times, and that can be done if you wish to proceed that way.
Does the board want to take a few minutes to review the new application? I looked at it at home.
I looked at it,
Okay.
but I'm fine if we want to take a few minutes. Are we concerned about, as a board, are we concerned about change of ownership, or are we concerned about change of control? Question, I guess
Notice that there's one question on here, who does the board contact at the agency, should we need to? And I think if that changes, it's important that we know that. It may be a manager that retires or leaves the company for one reason or another, and a new manager come on board. I think that we should always know who's in charge and who we talk to about that. I think it's question number 2, actually. My own preference, and we have it in here about 10% ownership. I think if more than 10% ownership of the company changes, then just for discussion, I don't know if we should have a new application and a new financial statement and all, but I think the board needs to know, or the administration needs to know, if more than 10% of the ownership of that agency changes. That's my own opinion.
And if you look at the first page under Colorado, they actually have that written out. It says the changes which require a new license application. And it essentially spells out if it's a sole proprietor or a partnership, it's going to be any change in the owners as opposed to a corporation. I mean, they're requesting 50%, but we could do something like that with 10%.
Especially with an LLC, because so many things can happen in that. What's the opinion of the board? 10%? 50%?
Asking to identify any shareholders over 10%. So saying a change in that would just be consistent with the application. I'm fine with the 10%.
Yeah, the application can be amended to the board's will. This is a draft document for your discussion. If you want it to be higher, that's certainly up to your will. This is per your direction from last time.
Sarah, in reading these other applications from the other states, is there anything that you see in these applications differ from the applications that's proposed here?
No, I thought Nicole really covered everything that everyone else had covered in their applications as well. They were pretty similar, just set up different ways, and some were longer, some, I think one state you had to fill out a separate application if you're a corporation, separate if you're an LLC, which to me, it just seemed like a lot of paper. So,
Hey, are we ready for a motion, Nicole?
I don't get to vote, so it's your.
It's
Oh,
your.
I mean, are you, are we, have we done all the discussion? Are we here to approve this application today?
That's what you'd like to do, yes.
Make a motion, we approve this new application.
A second.
Okay, motion's been made and seconded that we approve the application and require, and if I may, amend that to require a new application with over a 10% change in ownership.
okay, we'll discuss rulemaking for that because we're going to have to add something. When I talked to Mark, we kind of briefly drafted up something, just like if we were to state in the rules, as referenced in section 6220, 108, and 113, a change in ownership means, and then we would need to define it. From reading the other statutes for other states, I thought Colorado's was written very well to say, in the situation of a sole proprietor or partnership, if you want them to have to reapply for any change, we need to spell that out. And then for corporations, we'll need to put 10% in there and then decide if we want it, 10% in stocks and assets, 10% in ownership interest, however you want to define that.
So that'll be a matter for the next meeting.
I mean, we can put it on next meeting to discuss rulemaking, and that'll give you all some time to think about it, and I'll draft up something to have in front of you, and we can play around with it. Okay.
So the motion stands that we approve this application as presented. Is that correct?
I want to clarify, well, I think that may have been the motion in second, but we're actually, there's a renewal application as well. So are we approving both? I guess I want to make sure.
Yes, I'll amend that motion that it approves both, the new application and the renewal.
I'll second.
Motion's been made and seconded. All in favor, say aye.
Aye.
Okay. Legal report?
I'm not sure how you all do this. My other boards make me read to them, but I'm assuming, I think Jenica informed me that I don't have to read each of these to you, like some of my other boards require.
Yeah.
So just, we can start with one and any
Yeah.
questions you have and go down the list.
I think it's okay, and I think in the past what we've done is we've read through them, and as we get to one, we write that down, and then at the end, we'll go over the ones we have questions about.
That sounds
and then approve them
perfect.
all. Is that okay?
Perfect.
All right.
Generally, Keeling just read the case number and the complaint.
Yeah. So you need to read the case number and complaint into the minutes.
Into the record so that the video captures it.
Yeah, I'll just say number 1, 201502243331. Ready for number 2?
Yes, I'm sorry.
Okay, just,
Well, I'm skipping on ahead.
I was gonna say, just give me a signal and I'll read.
Okay, I'm on 7, actually.
Okay, I'll just go ahead and read through
Okay.
7 then. 2 is 2015-022-3311. Number 3 is 2015-022-3461. Number 4 is 2016-001601. Number 5, 2016-001621. Number 6 is 2016-001661. Number 7 is 2016-001691. Okay. Number 8 is 2016-001891.
On this one, we're suggesting, or you're suggesting, a $500 civil penalty for operating with an expired or operating without a license.
Yeah,
Is
and
that
they've been
correct?
expired since '08, so
Okay. For a long time.
There's, it seems to me there's something in our statute about a client that hires an agency that's not licensed. Would, uh, would we be wise to send a letter to the client, a letter of warning to the client? There's a lot of complaints about unlicensed activity here, and that kind of concerns me.
yeah, and in order for us to send a letter of warning to those entities, we would have to have a complaint opened against them.
I remember years ago, there was a company in Chattanooga collecting Comcast. Man, he had a big sign on his truck that I'm out collecting Comcast. And we busted Comcast.
So it would be us sending a letter to Comcast saying, you're using an unlicensed third party. Well, Jenica's looking, so we'll see if there's something that we can do for that.
Making them aware of the statute.
That
and the
they're
fact
using
that-
somebody
yeah,
that-
Right.
And I think it's only good for our good businesses that are collection agencies that are operating just like they're supposed to, and here is somebody that's not licensed and doing bad things. More questions about number 8?
No.
Okay, ready for 9?
9, 2016-001731.
Okay.
Number 10, 2016-002151.
talk about this one a little more. Seems, just my opinion, seems to me that there's two violations: threatening legal action on an account that can't be sued, and failure to respond to the complaint. Not to mention the rude discussion here.
Sort of intimidation.
This is a new licensee, and I hate to start off on the wrong foot with the company. I think this is bad. This is bad business, and we ought to bust him for more than $250. I'd recommend a $500 fine for threatening legal action when he's not authorized to, and $500 for failing to respond to the, or $250 for failing to respond to the violation, respond to the complaint. And
Fine with that.
I agree with that.
number 11,
Number 11, 2016-006171.
I'm fine with that.
number 12,
Number 12, 2016-006201 and 2016-006202.
this consumer had a complaint against two agencies for collecting the same debt.
Yeah, it appears that the complainant just included both when it was essentially only respondent 2 that was doing anything.
Number 13,
13, 2016-007131.
yes.
2016-008911.
Fifteen,
15, 2016-009021.
sixteen,
16, 2016-009061.
17?
17-2016-009101.
Eighteen?
18-2016-009551.
Not licensed activity, it's getting worse.
Yeah.
Bill and I were talking before the meeting, they're calling now and saying they won't give you an address, and you gotta you gotta go to Walmart and get a MoneyGram, and you gotta send the money over the phone and so forth. So it's coming, unfortunately.
Just to be clear, we weren't talking about any specific case.
No, no.
We were just talking generally.
That's right, sorry. I don't want to bust Nicole for
Right.
this. Have we done 19?
No, 19-2016-009651.
What's the problem with the surety bond?
I believe that the complainant alleged that their surety bond needed to be reviewed, but they didn't provide any information as to why it needed to be reviewed, and the respondent did not even, I don't even think they addressed their surety bond, or they told us that their surety bond was fine.
Well, we would know that, wouldn't we?
Yeah.
But we don't have any problem with it, okay. 20?
20-2016-009431.
Thank Chip.
Well, I mean, there are all sorts of problems that violations by this agency. It's not really right when someone disputes either indirectly or directly with a third-party agency. They have a duty to investigate and respond to the consumer. It's really not sufficient to just cancel the account back to the client.
Right.
So, I mean, I'm fine with $500, but there's several things wrong with this account. But
More than contacting the complainant after receiving a written request to cease contact?
guess what I'm saying, if I read this correctly, the respondent says they forwarded the request from the complainant to the client and then ultimately canceled the account back to the client. And that is exactly what the CFPB is trying to avoid, because you have consumer disputes a debt, you have a duty to conduct a reasonable investigation and communicate back, close the loop back with the consumer. It's not sufficient to just close the account. It just continues the problem. The account then gets assigned out maybe to another collection agency, and the consumer has to go through it all again. So I'm saying $500 is probably reasonable, but if we were in the business of trying to collect fees, we could probably add more to this, but.
I was gonna
I'm-
say, you do have the authority to up that to 1,000 if you wish.
Then I would move we up that to $1,000.
Motion's been made that we up that to $1,000. Is there a second?
I'll second.
And seconded, all in favor? Aye.
Aye.
21?
21-2016-009491.
Are you okay with $500? Okay. 22?
22-2016-014471.
Just for clarification on number 22, when there's a situation like this, obviously, or it appears that this is a bogus company, we make some sort of note in our system here, so if we continue to get complaints on this particular company, we can always use new information and maybe reopen a complaint that was filed previously.
Yeah, that would be a vote to close and flag the matter. And we can reopen it. When you say closure, you can reopen a complaint if new evidence arises. If you just dismiss a case, you can't reopen it.
I think we should, with as much of this as going on, we may ought to flag these and to see if we can recognize any kind of a pattern and maybe someday eventually find out who's doing it or what other people are doing it and attempt to stop it.
Yeah, this one had multiple complaints with the Better Business Bureau that were unresolved. So,
So they're pretty slippery, evidently. They're able to, okay.
23?
23-2016-014511.
Do we have the authority to ask the agency to pay this money back? Or are they, because the employee was working for the agency at the time, I don't know where we stand with.
That was kind of our discussion, and that's why we wanted to pose the question to you. We were unsure if we could hold the company liable for the money. I don't know that we could get the money back for them as just opposed to a civil penalty. Because that's kind of what the path we went down to, is that was their employee and you're liable for what your employees do.
Within reason, Chief Counsel has told us that we can ask for really anything in a consent order if you want to include that. But if they didn't accept that consent order, we went to formal hearing. That's not under your authority to make whole the complainant.
So it would just be a, will you
Or the
please
consumer.
give the money back?
Yeah, and we
essentially.
could basically say provide proof to the board that you have made the consumer whole.
Okay, so I'm just trying to make sure I understand the facts in this. An employee of the respondent answered the phone and then, excuse my country talk, but bogus up charges, couldn't find the account in the system, bogus up charges, and then had the consumer, fraudulently had the consumer send money to some MoneyGram account that eventually the employee must have stolen.
It went to the employee's personal address.
Okay.
So, I mean, essentially the employee said, here's my address, send it to me, and I'll pay it on your behalf. And they just took the money.
Okay, and now the employee no longer works there, so I'm sure the employer discovered something in this process, maybe not about this account, but for some reason they parted ways, or the employee left voluntarily. It is my belief the employer should reimburse the consumer and pay a penalty for improperly supervising employees. That is my opinion. Now, whether we have the authority to enforce repayment to the consumer, that's a legal question I can't answer. But to me, if I own or operate a collection company and I have somebody rogue on my collection floor and I don't know it, I have to make the consumer right. That's my fault. Indirectly, of course. That's my opinion.
Absolutely. And we can, like Jenica said, we can put that in the consent order and, just request that they, make them whole. And we could do something, and say $1,000 civil penalty for, failure to supervise. But if you repay the consumer, we'll knock it down to $250, or we'll, knock it down to 0 or 500, however you want to word that. We do that a lot with like licensing. Like if you get your license within 30 days, we'll reduce your penalty.
In the consent order, there's usually a cease and desist. How would you word that?
Cease and desist from practicing, from any violations of our law.
I really like the strategy. I'm not sure how to word that, but as an example, this is not a motion, Mr. Chairman, but it could be a $1,050 fine, which would be reduced, or civil, a penalty, which could be reduced to $250 if we can verify that the consumer's been reimbursed the $800. So the out-of-pocket for the company is still the same.
Yeah, and so your max is 1,000 for one violation. So we could do 1,000 to 250 or 200, however you.
I think asking them also for some, perhaps, assurance of that they've taken some steps to remedy this.
Yeah, we've seen that before where you kind of throw in a little, almost like a instruction to say, please be mindful of this in the future,
We know if this person was prosecuted?
Well, I think it should be turned over to the Attorney General for sure.
We can send a letter to the district attorney if you add that in your motion.
Well, I mean, that's fine, but also is it, I guess I'm sort of viewing it as if the company reimburses the consumer, if I were the employer, I would go after the employee. But if we want to initiate that, we can.
I definitely think we should.
So, Mr. Chairman, let me see if I can put that into a motion.
Okay.
I would move that we assess a penalty of $1,000, which can be reduced if the respondent is able to prove repayment of $800 to the consumer, and that we can verify that, be reduced to $200. But also request that the respondent show evidence that they have taken steps to properly supervise their employees, to remedy this so no other consumers are harmed.
What type of evidence would you want?
For us, it would just kind of be
Or-
instructing them, just telling
Okay.
them in the
So-
future,
All
be,
right.
please be mindful
Instructing-
of this.
So
you know.
instead of providing proof, I would amend that to say, informing them that it's their responsibility to supervise their employees to prevent this from happening again, and that we notify the district attorney.
I second that motion.
Motion's been made and seconded. Are there questions about the motion? Okay. All in favor, say aye.
Aye.
24?
Okay, number 24, 2016-016341.
Questions about this? 25?
25, 2016-014551.
So the complainant never told the respondent that it was his spouse, it was his wife.
Yes, and we've actually received a signed letter from the receptionist that she is not his spouse and that they left the message with her.
I think $1,000 is more appropriate for this kind of action.
I do too.
All in favor of $1,000 civil penalty on number 25?
What was the motion? Who was the motion and the second on that one?
We had a motion to increase the civil penalty from $500 to $1,000. Chip made the motion.
second.
Elizabeth seconded.
All right, thank you.
All in favor, say aye.
Aye.
Number
26.
26, 2016-016301.
$27?
27, 2016-019901.
So this complainant received 2 more letters after he had requested a validation of the debt?
Yes.
Is there some discussion? Seems to me that would be a violation. I don't necessarily have a problem with the credit reporting because it's being reported as disputed, but sending 2 letters without, sending 2 more letters before the respondent provided validation. Missing something, Sarah?
Double checking it.
Okay.
Well,
Well, it looks like the law firm has proof that they sent the validation, their response to the validation request.
in September, which
September.
was several months before the 2 more collection notices went out.
Okay. 28, oh, that's it.
We are done. I think we should probably make a motion to adopt it with all your changes as a whole, just in case we missed any.
And I have one question back on number 2,
Yes, ma'am.
and it's just, it's concerning the sending of 12 letters to collect this debt. That caught my eye. I didn't know if we asked what time frame that was, but that seems a little excessive.
Yeah, it does.
Yeah, there was no time frame noted from the complaint or the respondent.
Perhaps a letter of warning.
We could do a letter of instruction or warning.
Yeah.
Yeah,
Like
12 is
Wes said,
excessive,
12 seems, yeah.
given if it's a reasonable time period, it's,
Would you prefer a letter of instruction or a letter of warning?
I think a letter of instruction.
Okay.
I'm not sure that that's a violation, so,
Since we don't know the time frame.
Yeah.
right.
That's all.
I'd entertain a motion to accept the legal report as amended.
So moved.
I'll second that.
Motion's made and seconded. We approve the legal report as amended. All in favor?
Aye.
A clarification question. On number 8, did you want to give the notice to the client? I found the statute TCA 622118. User responsible for asserting service is licensed. Any person who places an account with a collection service is responsible for determining that service is licensed as required by this chapter.
Yeah,
Do we know?
We'll have to look and see if we actually know who the client is in this case.
Since it was filed by the consumer and not the client.
if we can find out, I think it's important that we do that, not only for the creditor, but also for the industry. We have a lot of folks in this industry that work real hard to stay legal and up to date and trained and what have you. So I think it's incumbent on us to promote that industry.
Enough
Legally.
competition out there that's.
Yeah, there's plenty of competition that's good
Good
competition.
competition, we don't need that.
Okay. Legal report. Any new business? Gosh. Not. We'll stand.
No,
I move we adjourn.
Motion move, we adjourn.
second. All in favor?
Okay, second, gone.
Thank you.
Thank you. And welcome to our new board member.
Yeah.
You didn't get to ride the goat yet, but it's outside. Oh, it's great.
Bart,
Yeah. I'll have just-
Bart runs the best
Congratulations.
meetings
So much for
around.
coming. I know it was